So, what are the limits to the state surveillance and where does one really draw a line?
So this is actually a very, very live topic in today's India, because if you see the Information Technology Act or if you see the original Indian Telegraph Act, there was a provision under which, or there is a provision under which the state could, put anybody under surveillance. And under the Information Technology Act, they used the word computer resource. And today, any iPhone or any smartphone is like a computer. So it really comes under the definition of a computer resource. Now, the purpose of the provision under the Information Technology Act or the Indian Telegraph Act was to grant specific approvals. When I say specific approval, means that if supposing the state has information about a particular individual indulging in anti-national activities or doing something which is against the sovereignty of the state or against public order, then you have to first build up a case for him that he is doing this, that and the other, and then you have to seek permission to put him under surveillance. Now, surprisingly, and I think it's a very wrong way of utilizing the power under Section 69, in the year 2018, a general notification is issued empowering 10 organizations like the ED, the CBI, the Delhi Police, the Income Tax, RAW, IB, etc., to intercept any information from any computer. Now, that section which was used for issuing that notification really did not permit to issue that kind of a general notification. And the result is that now with this notification, using this notification, these organizations have bought software like Pegasus, which can latch onto anybody's telephone and even snoop even onto a switched off telephone, switch off the camera of a switched off telephone, or switch on the mic of the switched off telephone, and start snooping and seeing everything that the person is doing. Now, the problem with this notification is, or rather this exercise of this power under Section 69 of the IT Act, is that by empowering the investigating agencies to have this kind of a software, you have completely obliterated the checks which were there in the system, which was that if an investigating agency felt that a person X or a person Y is indulging in some anti-national or some activity which is injurious to the state, then you grant a specific approval. And that specific approval was to be then granted by a certain level of officers. So like used to be either district magistrate under the Telegraph Act or the secretary to the government in the IT Act. And then after getting that approval, you had to go to the service provider with that approval, and then the service provider permitted you to do the surveillance. Now this check has completely gone. With the investigating agencies having the authority to latch onto anybody's phone, they can straightaway start snooping without even keeping any record. That's how investigation is all about. And start listening to what people in position, people in opposition, people in media, people in judiciary, what they are talking, and trying to find out the weak links in their personality. And if they find something actionable, in some cases, then they are, of course, supposing, for instance, in the unauthorized conversation, if they find that some money is to be delivered at some place at a particular point of time. Although they have not used that information officially, and they can't use it officially, but they can definitely go to that place and, raid that place and find that money. And finding the money itself then becomes a matter of investigation, a large amount of stacked cash. So the misuse that is happening now of the notification of 2018 is that this checks and balance which were there in the system. Now, what was the check in the system? The check was that under the rules, if you got a permission to do surveillance, you couldn't do it beyond a particular period of time. There was a method of reviewing a permission granted once, and so on and so forth. So whenever a permission was granted, it was subject to, firstly, there was record keeping of a permission having been granted. Somebody had satisfied, the investigating agency has satisfied some senior functionary of the state that this is a case where the surveillance needs to be done. and then that permission was to be taken to the service provider. Here the investigating agency becomes the service provider also, and becomes the authority which has the power to grant the permission, and it does the snooping without any check, because he's not supposed to even maintain records of from when to when he has done surveillance of whom. And this information with these investigating agencies are being misused in a very big way in this country today. And I think the government should really rethink on withdrawing this notification of 2018. And also, if any organization has purchased a software on the basis of this notification, that software should also be directed to be impounded, because even keeping that software with them under an unauthorized notification will amount to a continuing abuse without the investigating agency having the authority to do so. So I think it's a very serious inroad on privacy. Privacy has now been held to be a fundamental right, and in spite of it being held a fundamental right, this kind of snooping by investigating agencies without any checks, without any control, without any record keeping of people in position is according to me a dangerous thing for any democracy, and it is something which needs to be deprecated.
So just a follow-up point, do you think it has a chilling effect on democracy?
So what has happened now that if you see people in position who know about this software have gone back to the old Nokia phone, where this kind of a software is, which is actually not a computer. So people are going backwards to save themselves from the attempt of any surveillance. But anybody having a smartphone, and today everybody, even a driver in your home, has a smartphone. So the kind of proliferation of a smartphone in this country, it is impossible for somebody to ensure that he talks on a different phone every time he wants to talk something which is something of a confidential nature. I'll not say wrongdoing, but which is of a confidential nature, or which he does not want, or which is his private nature, which is his private life, and he doesn't want people to know, because everybody has his own private life, and that part Supreme Court has very clearly held is a purely fundamental right of every citizen. So that invasion of the privacy of the individual can be done at will of anybody and everybody, which according to me is a very retrograde step, and it is anti-democratic, and it is also unauthorized, because the section under the IT Act does not permit the agencies to do this activity themselves.